All rise. The Court of Appeals Division 1 is now in session.
Good afternoon. You may be seated. We are here on our case number 1CA-CR150684, State of Arizona versus ESCALANTE. Counsel, as you both know, you're each allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you need to keep track of it yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful if you would give us your name and the name of your client for our recording. We have reviewed the briefs and studied the record in the case. We've also discussed it in our conference together. So with that, you may proceed.
Thank you. May it please the Court, my name is Michelle DeWalshy. I am appearing on behalf of Mr. Eric Antonio Escalante, who is the appellant in this matter. In this case, a phantom homeless man handed a note, a handwritten note, to a police officer. That police officer then gave the note to a second police officer, his partner. The second police officer rewrote the note into an email and sent that email to a group of, a third group of police officers. That email was introduced at trial, and that despite the fact that the homeless man was never identified. The police officers never even asked him his name. They couldn't even give a very good description of what he looked like physically. And this represents only one of 7 separate violations of Mr. Escalante's constitutional right to confront his accusers, which occurred in this trial. And that occurred after the government conceded in a pretrial motion that all of this was inadmissible hearsay and should not be admitted at trial. All 7 of these Confrontation Clause violations constitute fundamental error. And the defendant can show that, the appellant can show that he was prejudiced by that error. He can show that because the jurors in this case were really doing their jobs. They asked a lot of questions. And they asked questions about a photograph that was entered into evidence, which was based on this inadmissible hearsay. That question shows that the defendant was prejudiced. In addition,
What was the question?
The question was about regarding photos that were allegedly taken by a property manager, concerned citizen, who was never identified and never testified at trial. They allegedly depicted the apartment of Mr. Escalante after he had moved out of it. The pictures were taken 6 months before they were ever handed over to the police. And the picture, one of these depicted a piece of glass on a counter, a kitchen counter, that had what looked like a white powdery residue on it. The juror's question was that ever tested to see whether or not it was methamphetamine? And the fact is it wasn't, it couldn't have been, because the police didn't even know about this photo until 6 months after. At a minimum, it had allegedly been taken.
Was that question answered?
The question was answered, and it was answered that no, because we did not receive the photos until later. The jurors also asked questions which belie that they were struggling with this evidence. They asked a question as to whether or not the methamphetamine that was found in the roadway could be compared chemically with the methamphetamine residue that was found in the scale in Mr. Escalante's truck. The answer to that was no, it could not. But it does show that the jurors were really reaching. They were trying to find some concrete evidence that matched, that connected the methamphetamine in the roadway with Mr. Escalante. They asked another question, were fingerprints...
There actually was a pretty good connection, was there not, between your client and the meth on the roadway, in that he was driving up Highway 260, knew he was being followed, turned off onto Prairie Lane Road, and right where he turned off was where the bag was found.
The bag was found 1,500 feet away from where he was stopped in the traffic stop. The bag was found 2 hours after this traffic stop was made, after all the police had left the scene and then returned to the scene. One police officer, Detective Bowers, returned to the scene and allegedly found this in the roadway. And so that did connect him, but there was no direct evidence. No police officer saw him toss any evidence from a vehicle. There was no one to testify that he had sold methamphetamine to them or that he had bought or purchased methamphetamine from anyone else in order to sell it. And so the other evidence of guilt in this case is pretty slim. And so what we believe those questions of the jurors actually show is that they had doubts. They were struggling to try to figure out what was right, the right decision with this evidence. And they were carefully considering the inadmissible evidence as far as the photo that was based on inadmissible hearsay. Now, yes, Your Honor.
I'm sorry. What was the defense? What was the nature of the defense?
The defense was that I did not commit this crime, that the state cannot prove that I can commit this crime. There was no defense raised, which under 404B would have.
Was it not I was framed?
Well, his defense is that you cannot prove that I did this. But yes, his attorney did argue that there is no evidence, and so they couldn't prove it. And I believe his defense was not that he was framed so much as that the detectives, from the very get-go of this investigation, believed what they wanted to believe. They saw what they wanted to believe.
Wasn't the accusation made that because they had, the officers had followed your client and not found drugs in his car, that one of the officers had come back and planted that bag of meth in the street?
That was not, I don't believe that was made outright. However, that was something that was sort of insinuated that was part of his defense. However,
and that the scales was planted in the vehicle?
That also, that could be construed as part of his defense. His defense was the police were trying to see what they wanted to see. I would also like to point out that drug courier profile evidence was admitted as well throughout this trial, and this is in, this is an opposition.
All of these 7 pieces of hearsay evidence that you were so, if they're so damning, why wasn't there an objection to any of them?
Your Honor, I can't answer that. Obviously, we can't know from the record what the trial attorney, why he did not object to this. There were 2 objections to the hearsay. The 2 objections, in both cases, the prosecutor said, let me rephrase this, Your Honor, and basically ended up eliciting the same information without the words, he said this to me, or I heard this from somebody. But it was the same information, and that information was that Eric Escalante was a drug dealer. And this was brought in, that testimony was introduced throughout the trial, and this is in direct violation of Mr. Escalante's constitutional right to confront his accusers. In addition, there was the drug courier profile evidence that was admitted throughout this trial in State v. Lee, and also later in Biger v. Coconino County. The Arizona Supreme Court has determined or has ruled that drug courier profile evidence is inadmissible as to substantive proof of guilt. In this case, what we had was almost what seemed like an outright character assassination. From the opening statement all the way through to closing argument, there was drug courier profile evidence introduced over and over and over again. Mr. Escalante did not raise a defense that would allow this character evidence to come in under Rule 404B.
But didn't he use that information to show that the police were really out to get him? Like following him to Phoenix and putting the thing under his car and that kind of stuff. Well,
I believe that the defendant is entitled to a defense. The point is the character evidence is not admissible. That is, pursuant to the rules of evidence, character evidence is generally not admissible. It may be admissible if you raise certain types of defenses. If he said, I didn't know that there were drugs in my car, then that character evidence could come in to show that he was, in fact, he did have knowledge that those drugs were there. If he said, it was a mistake of fact, I thought that what you found in my car was baby powder, then of course that character evidence would come in under the exceptions to 404B. None of those defenses were raised in this case. And so the evidence was inadmissible character evidence that under Lee, under Biger, and then also under Ketchner, although not drug courier profile evidence, the Supreme Court of Arizona has said is not admissible as substantive proof of guilt.
It's because the law is so clear, and because the evidence and argument were so rampant, it's in the trial. It's hard to figure out why defense counsel didn't object. And
Your Honor, I agree with you, and I wish that defense counsel had objected, because we would be here under a different standard of review, a much lower standard, and it would be easier for Mr. Escalante to get relief. But I believe that the attorney's trial strategy is irrelevant on fundamental error review.
Well, it's a right essential to his defense, and if his defense used the very evidence that you now claim was error to admit, and why isn't that something that we need to consider?
Well, a right essential to his defense is only one part of fundamental error review. There is also error that goes to the foundation of the case and that affects substantial rights of the accused. 7 violations of his right to confront his accusers, and all out, character evidence being introduced over and over again throughout the trial. These errors amount to fundamental error, and he can show that he was prejudiced because of that error. And for that reason, this is why we have fundamental error review, because the trial attorney's strategy does not matter. What matters in fundamental error review is whether or not the defendant's rights were violated, and in this case, they were. Also, the state has argued that this is modus operandi evidence. We do believe that because the defense was not raised as it was in Gonzalez or as it was in Garcia-Quintana, that the defense was not raised, that he was an unknowing courier, or that he had no knowledge that drugs were in the car, that those 2 cases really don't apply here, because, again, this is character evidence that should have been disallowed because of unless he raised a defense that would open the door to it under 404B.
what sorts of defenses or circumstances do allow admission of MO evidence in drug cases?
Well, the circumstances that would allow it, as I said, would be raising a defense that would open the door to it. And so that would be, I had no intent to sell. This was a mistake of fact, or this was, I was an unknowing courier. That would allow it to come in. The state also mentioned that it might be foundational testimony for experts. Unfortunately, that's typically in cases where we have physical evidence that it may be very difficult for the jurors to understand. In cases like State v. Walker, or even in U.S. v. Bonney, which was cited by the government, those cases involved a ledger, and that ledger had very cryptic writing in it that would be very hard for the jury to really understand what was being recorded in that ledger without the help of an expert to testify. In this case, all of the officers testified as expert witnesses. And not only that, but they were also allowed to give their opinions as to why they believe Mr. Escalante's behavior characteristics fit the drug courier profile. And for those reasons, we do believe that fundamental error occurred, and he can also show prejudice on this issue. And that is also in the form of jury questions. And so jurors ask questions about cell phones. They heard almost every officer testify that drug dealers use cell phones to communicate and to set up their drug deals. They heard testimony about the source and demand cities, which is explicitly prohibited under Lee and under Biger. And they asked questions about these things. They asked was a second cell phone ever found in his truck? They asked, did he ever give a good reason for traveling to Phoenix that night after they had heard that that was a source city for drugs?
Well, they'd also heard, had they not, that he drove from Cottonwood down to Phoenix, went to a house for 15 minutes, and turned around and came right back.
That is correct, and that is something that the State v. Lee has explicitly, the Supreme Court in State v. Lee has explicitly said that that is improper drug courier profile evidence unless the defendant opens the door to that evidence.
That's not courier evidence, that's evidence of where he went that night and how he might have come in to possession of the methamphetamine that was found in the road.
Yes, Your Honor. That where he went that night, you are correct. That is just where he went that night. The problem is when when many of the officers are testifying that he went there, that 35th Avenue and Indian School is a known drug area. Phoenix is a known drug source city. I-17 is the pipeline to get drugs from Phoenix up to Yavapai County. All of this evidence, in conjunction with what the defendant did to match that profile, was inadmissible drug courier profile evidence.
I don't disagree with you that much of that evidence was completely irrelevant to what the case was about. But the defense attorney basically said, look at what you've been given. He says, they dragged you in, 14 of you in here, to sit here for 4 or 5 days, and all they put on was a lot of smoke, is the way he put it. He used this multiplicity of whatever this evidence was about what drug dealers do, and compared it to the amount of evidence that there actually was that the defendant was guilty. And so that is why he didn't object to it. He allowed the state to parade one witness after another to talk about what drug dealers do because he knew that it wasn't hurting him.
And yes, Your Honor, I do agree with that. I don't believe that on fundamental error review, however, it's that the defendant should lose his right to have this court review and review this case and to provide the remedy, the only remedy that we believe is appropriate in this case, which is a new trial.
If the defense attorney's strategy was poor, he does have a remedy, right?
Your Honor, the fundamental error review is here for the reason that the defendant, if his rights are violated, and if that error goes to the foundation of the case, which the error in this case we do believe does go to the foundation of the case, then the trial attorney's strategy is really irrelevant. And so any other remedy that he might have does not mean that he does not have this remedy available to him, and that's why fundamental error exists. At this time, I would like to reserve my last 4 minutes for a rebuttal, if permitted. Thank you.
Thanks.
May it please the Court, Eric Knobloch of the Arizona Attorney General's Office, representing the state of Arizona. The standard of review for both issues here is fundamental error. Here, appellant cannot establish his burden of showing that there was error, that error was fundamental, and that fundamental error prejudiced him. On the first issue, there was no fundamental error because the state did not elicit the testimony as drug courier profile for the purpose of demonstrating guilt. The distinction between this is, in the drug profile testimony, the expert testifies to the existence of a profile, delineates those characteristics of that profile, and then explicitly compares defendant's conduct to the profile. For example, in Lee, the expert testified to the existence of a drug profile and then delineated those factors such as a large hard-cased luggage, the last flight out of Chicago, checking in extremely late for the departing flight, lack of identification on the bag, and then the gender and age of a typical courier. And in Lee, the court stressed that the state used that testimony for the expressed direct purpose of showing guilt.
Well, in this case, what was the purpose of showing, for example, that the defendant had a camera outside his home?
That was the purpose of describing the evidence, the specific evidence in this case, and why that was relevant to the case and to the charges.
Relevant to?
It was relevant to show that he was engaging in counter surveillance. And that also went to the fact of his girlfriend doing counter surveillance outside of his apartment.
You've got to acknowledge, though, that much of this, drug dealers drive to Phoenix to get drugs. Drug dealers drive on I-17 because they can get drugs that way. I mean, a lot of this stuff is so abstract in general that it has little, if any, application to the facts of this case. The facts of this case are they started investigating this guy, they surveilled his apartment, saw people coming and going, got a warrant, put a GPS on it, tracked his car to Phoenix one night, got him coming back up, followed him. When he figured out he was being followed, he turned off on a road, and later he found drugs near where he turned off. That's what this case was about. So then you got days and days of talking about what drug dealers do or what drug couriers do. I mean, you're not even alleging this guy was a drug courier, you're saying he was a drug dealer. Couriers are like the middlemen, and they have little furtive movements that have to be explained. But if your theory is correct, this guy went to Phoenix to get his supply, came back up so he could sell it. And the question is, did he do that or he didn't do that?
Well, in State v. Gonzalez, this court stated that this type of evidence is admissible, is not limited just to the complex courier cases, the complex drug cases, but it is also admitted in non-complex drug courier cases, such as the present case. And in State v. Gonzalez, the defendant was only charged with the same charges that he was charged in this case of transporting dangerous drugs. And so the evidence was relevant to show why he went down to Phoenix, like Your Honor said.
I mean, I can't help but ask, if you were sitting in that jury, would you have convicted this guy because of the drug courier evidence or because you found a bag of meth on the street where he turned off?
If I was a juror in this case, I would find him guilty because of the overwhelming circumstantial evidence in this case.
And that would not have been because of what drug dealers do in other cases, would it?
No.
Well, what is the evidence, the admissible evidence, setting aside the drug courier profile / MO evidence? What's the evidence that was sufficient to convict him?
And this evidence shows that there was no prejudice, and this applies to both issues. And it is essentially evidence that he drove 2 hours to Phoenix, stayed 15 to 20 minutes before returning, that when he was pulled over, a canine was brought around the car and indicated that there was a narcotic odor in the vehicle. A subsequent search of his vehicle found a scale with meth residue. And when Officer Bowers returned to the scene 2 hours later, he found a substantial deal of methamphetamine on the side of the road in the area where appellant had driven his car. And that
Not just driven his car, had driven his car off of the highway to Cottonwood where he lives, turned off onto a little road in Verde Village where he doesn't live.
correct.
And confronted the police officers
Correct.
when he was stopped.
And there was officer testimony that when they pulled him over, his window was down, which the officers thought was peculiar for that time of year, which was January.
Where in the road was the bag found? In the center or on the side?
I believe it was on the center. And that's why the officers testified that they wouldn't have been able to see it, and that may be why they had missed it initially, that he had thrown the methamphetamine from the vehicle, because they were on the other side traveling, and so they wouldn't have seen it come from that area. And not only that, but the conditions of that night, it was very dark, and the officers testified that the roadway had very little lighting.
So, counsel, based on what you just described, it sounds to me like you have a very strong case. So why would you spend days and days and days going into drug courier evidence?
Well, that testimony, as the state has stated, is that it is relevant to help the jury understand and educate the jury on this type of case where they have no background in. And a lot of this evidence, the evidence that was found,
They have no background on how to drive from Yavapai County down to Phoenix. No no background on that they only spent 15 minutes in Phoenix, no background on when they were driving back. They noticed there were 2 police officers that were following the gentleman, so he turned off the road. I mean, stop me when you get to the point where you think they have no background.
Well, Your Honor, I think the state is allowed to show the context of the evidence that is presented. For instance, with the coffee grinds and the dryer sheets, the state is able to show that from a qualified officer, and the State v. Gonzalez and State v. Garcia-Quintana discussed this, that they can educate the jury and assist the jury in helping establish why that evidence is relevant to the crime
That's what,
charge.
15 minutes?
Sorry?
15 minutes to bring out that evidence? About 15 minutes to bring out the evidence about the coffee grounds and the dryer sheets.
Correct, and they did that. And they also provided as foundational evidence for their opinion of why he went to Phoenix, their training. And so that's why that was
Isn't that
relevant.
the direct evidence of drug courier profile that our courts have said should not be presented? Their opinion that was in fact a drug courier in that scenario?
No, Your Honor. I think the importance of the distinction here is the purpose that the state is using that evidence for, or that testimony for. Here it is to assist the jury, and not in State v. Lee, where that was the present risk, that they were using it for the substantial evidence of his guilt. And on this,
I guess I'm not sure that there's a distinction in the Yavapai County to Phoenix pipeline.
I mean, I live in Flagstaff, and I used to go to Phoenix to go to Target, because we didn't have a Target in Flagstaff. You could say it's a pipeline for,
Target product?
exactly.
well, then I think
But
that
see, these are things of such common knowledge. If you're a business person, you may need to go to get supplies for what you sell to people. And usually MO evidence under 404B is limited to sort of peculiar MO, something that's distinctive to the particular defendant, instead of, well, he drove to Phoenix. I mean, the fact of driving to Phoenix and staying for a few minutes and turning around in context would seem to have some resonance in this case. But that's what the jury's good at, is understanding what happened.
Yes, the fact that he spent 4 hours on the road with 15 minutes in between for no apparent purpose. I mean, to me, that's the relevant evidence, not that, there's a lot of drugs in Phoenix and you have to go to, if you're in Yavapai County, I don't believe this, but if you're in Yavapai County, you have to go to Phoenix to get your drugs. That's the part that I think we're offended by.
okay. And even if the court does find fundamental error on that issue,
Find error on
correct
that.
error on that issue, then the court still should find that it's not fundamental, because he used it as a defense strategy and because of the overwhelming other evidence. On the second issue, appellant is unable to demonstrate fundamental error because the state did not elicit the supposed hearsay testimony for the truth of the matter asserted. Instead, the purpose was to show how the investigation unfolded in the sequence of events. And although appellant made comments that it was seven confidential informants and concerned citizens altogether, and that the scope was massive, had appellant objected, the trial court then could have put in a limiting instruction or sanitize the testimony. But in this case, it almost seemed to be appellant's strategic plan not to, because he didn't want all those confidential informants or concerned citizens coming in to testify against him.
Well, he made the defense lawyer made the plausible argument that you said you had all these confidential people saying there's drug activity going, but you didn't produce one of them.
Correct. And in the closing argument, the appellant's counsel stated, because if they had existed, they'd have come to court and you would have heard from them. And so that seemed almost to back his strategic plan in his defense. And Henderson guards against this type, where the defendant sits on it or sits still silently and takes his chances on a favorable verdict, but then reserves the whole card for a direct appeal on a matter that was curable at trial. And then, as stated, even if this court does find that the hearsay was error, the overwhelming other evidence supports otherwise supports the conviction. And I talked about the long list, but there's also another evidentiary element that the jury heard, and that was appellant's own consciousness of guilt. And he refused to admit, even when confronted, that he went to Phoenix, even though the officers had GPS that showed he went to Phoenix.
Well, he said he came from Camp Verde, which was at least partly true.
Correct. Well, and then, but when explicit...
If you get off the freeway and don't go right and go left, I don't know that you really go to Camp Verde, but...
But then when asked about whether he went to Phoenix, he still maintained, even through all of that he never went to Phoenix and that it was not relevant. And
because they told him they stopped him because of his blue light. Didn't they say we stopped you because you have a blue license plate?
Yes, they did.
Blue light on your license?
And he also made the comment that they were coming after him from the beginning. And then the final consciousness of guilt evidence that was elicited was that appellant made an incriminating jail phone call where he stated that he's going away for a long time because of that person right there. For these reasons, appellant cannot carry his burden of demonstrating fundamental error on either issue. And if there's no further questions, the state respectfully requests that this court affirm the judgment and sentences of the trial court.
Thanks.
Thank you. I would like to first point out the government mentioned Henderson and saving this as a whole card for an appeal. I would again like to reiterate that if he had objected at trial, we would have a much easier time getting relief on appeal.
Well, you might not need it, because the trial court may have excluded all the evidence if you had made a proper objection.
Your Honor, that may be true. We can't know. We can't know what would happen. And so I do say that this is the reason that we have fundamental error review. I also would point out the government, again, was talking about Gonzalez and Garcia-Quintana. And in those cases, those were defendants who raised the defense. I didn't know that there were drugs in the car. And that is how that evidence was admissible as modus operandi evidence under 404B. And then also I would like to hit on the fact that these officers were not testifying as experts. What they testified to when it comes to the drug courier profile evidence was the very definition of drug courier profile evidence in State v. Lee, and also in Biger. The source and demand cities, the fact that his girlfriend decides to take a stroll from the apartment and appears to have no particular purpose in mind, according to Detective Sin. The fact that he had tool marks on the screws in his dashboard in a nearly 30-year-old truck that had an aftermarket stereo. The jurors heard about this type of evidence over and over again, and the jurors...
You're right that it was highly repetitive.
Yes, it was highly repetitive, and I do believe that the jurors were really doing their job. They asked a lot of questions, and I think those questions reveal that they were grappling with the inadmissible evidence. And absent all of that inadmissible evidence...
Them to grapple. We want them to talk about the evidence and ask and consider pertinent questions. So it doesn't necessarily show they were having a hard time. Sort of shows the jury at work.
We do certainly want them to grapple, but we also want to make sure that the evidence that they're grappling with is admissible and is not violative of the defendant's constitutional rights, which is what occurred here. And so, for that reason,
you're pointing out that are you not that this evidence just didn't fly by, that the jury focused on the evidence sufficiently to ask questions about it, and therefore that's how we know that the jury paid attention to the evidence.
That is correct. That's how we know that the jury was considering this. They were considering the evidence carefully, as it is their job to do. And also, I believe the other questions trying to connect the appellant with the drugs on the roadway showed that they were having a hard time doing that there was doubt. I believe that prejudice is shown, and I believe that there is a reasonable probability that the jury would have decided differently had they not been Basically, had they not had this barrage of inadmissible evidence presented to them. And so for those reasons, we believe that the fundamental error did occur. The constitutional, Mr. Escalante's constitutional right to confront his accusers was violated 7 times. That evidence was to show that he was a drug dealer. And this is evident because the prosecutor in his closing also mentioned it and said, it sounds like he was a drug dealer. He was inviting the jurors to say that. I believe that Mr. Escalante has shown prejudice. He has shown that fundamental error did occur. And for those reasons, we would ask for the only remedy, which is a new trial. Thank you.
Thank you. Thank you to both sets of lawyers for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.